The first thing I saw wasn't my house. It was a yellow excavator sitting where my driveway used to be. Chunks of broken concrete were scattered across my front yard, like someone had dropped bombs while I was gone. Fresh tire tracks cut through the grass my father and I had spent years keeping alive. A cloud of dust still hung in the warm afternoon air as workers in orange safety vests casually loaded shattered pieces of my driveway into dump trucks. I slammed my truck into park before it had fully stopped. "What the hell are you doing?" I shouted, running toward the equipment. A man wearing a reflective vest glanced at me without the slightest concern. "You the homeowner?" "I've been the homeowner for 14 years. He looked over his clipboard. "We were told the HOA approved the removal." "My driveway isn't HOA property." Several workers stopped what they were doing. One quietly lowered his shovel. Another avoided looking at me altogether. Then a woman wearing an expensive cream-colored blazer stepped confidently toward me. I recognized her immediately. Linda Mercer, president of the Oak Ridge Estates HOA. She smiled as if we were meeting at a neighborhood barbecue instead of standing on top of thousands of dollars worth of destruction. "Mr. Carter," she said calmly, "you're finally back." I stared at her in disbelief. "You did this? We improved a community drainage issue. You destroyed private property." She folded her arms. "The association has legal authority under the community maintenance guidelines." "No," I snapped, "you don't." Her smile never moved. "You should really read your covenants." Before I could answer, a white county pickup truck rolled slowly onto my damaged property. The words County Planning and Development were printed across both doors. Two officials stepped out carrying measuring wheels, clipboards, and cameras. One of them looked around silently before turning toward Linda. "Good afternoon," he said. She immediately switched to her polished public voice. "We've been expecting someone from the county." The inspector ignored the greeting. Instead, he pointed directly at the excavator sitting in my driveway. "Who's responsible for authorizing this excavation?" Linda confidently raised her hand. "Our association approved the work." The inspector nodded once. "Great." He opened a folder. "Then we'll just need to see the county excavation permit." For the first time since I'd arrived, Linda Mercer stopped smiling. The look on Linda Mercer's face stayed with me long after the county inspector asked that single question. "Can we see the permit?" 5 simple words. 5 words that somehow drained every ounce of confidence from the woman who had spent the last 10 minutes acting like she owned my land. I didn't know it then, but those 5 words would unravel a scheme that had been quietly growing inside Oak Ridge Estates for months. "My name is Ethan Carter. I'm 43 years old, and I own a small civil engineering consulting firm in Franklin, Tennessee. My job has always revolved around property lines, drainage systems, grading plans, and construction regulations. Ironically, I spend most of my days helping contractors avoid exactly the kind of legal disaster that was now sitting in front of my own house. That was the part that still amazed me. The HOA hadn't just picked the wrong homeowner. They had picked someone who understood permits, easements, and county regulations for a living. The house itself meant far more to me than its market value. My parents bought the property in 1991 when Oak Ridge Estates wasn't even a subdivision yet. Back then, it was a quiet rural road lined with maple trees, open fields, and families who actually knew each other. I learned to ride a bicycle on that driveway. My father taught me how to pour concrete there after a freeze cracked one corner when I was 16. Every expansion joint, every slope toward the drainage ditch, every measurement had been planned together. After my parents passed away within 3 years of each other, I inherited the house. Friends told me to sell it. Developers offered me more money than I'd ever imagined. But every room held memories that couldn't be replaced with a larger paycheck. I restored the home instead, updating the plumbing, roof, electrical system, and landscaping while carefully preserving its character. For years, life there was peaceful. My closest neighbor, retired firefighter Mike Dawson, often waved from across the street while walking his golden retriever. Across the cul-de-sac lived Angela Brooks, an elementary school teacher who organized neighborhood cookouts every summer. Kids rode bikes until sunset. People actually stopped to talk instead of hurrying inside. Things began changing about 4 years ago. A developer purchased several empty parcels nearby and transformed them into an upscale subdivision called Oak Ridge Estates. Along with the new homes came a mandatory homeowners association led by Linda Mercer, a former corporate manager who seemed to believe every disagreement required a committee meeting and a certified letter. At first, the HOA focused on ordinary things: mailbox styles, lawn maintenance, holiday decorations left up too long. Most homeowners rolled their eyes, paid their dues, and moved on. I kept my distance. I attended meetings only when absolutely necessary, voted when asked, and otherwise lived quietly. Then, about 2 months before my business trip to Colorado, strange things started happening. Bright orange utility flags appeared along the edge of my driveway without warning. I assumed the county had scheduled underground utility work. A week later, the flags disappeared. Then someone spray-painted small white markings across the concrete near the road. When I called the utility companies, each one gave me the same answer: "We didn't place those markings." That answer didn't sit right with me. Then Mike Dawson knocked on my front door one evening. He looked unusually uneasy. "Ethan," he said quietly, glancing over his shoulder before stepping closer, "I think your HOA has been holding meetings about your property, and they stop talking every time someone asks why." Mike's words stayed in my head the entire week. "I think your HOA has been holding meetings about your property." I laughed it off at first. "My property? Why?" He rubbed the back of his neck, clearly uncomfortable. "I don't know. I only heard bits and pieces. Something about drainage, access, and a vote. Every time someone asked for details, Linda said it was confidential until the project was finalized." "Confidential?" I frowned. "HOA meetings aren't supposed to work like classified government briefings." Mike shrugged. "I figured you'd want to know." I thanked him, but I convinced myself there had to be a reasonable explanation. After all, I hadn't violated any HOA rules. My dues were paid. My landscaping was immaculate. My house had won the neighborhood's holiday lighting contest 2 years earlier. There was no reason for me to become the center of attention. Then my business trip came up. A longtime client in Denver needed me on site for nearly 3 weeks to oversee a commercial drainage redesign after severe flooding. The timing wasn't ideal, but the project was too important to refuse. Before leaving, I installed fresh batteries in my security cameras and asked Mike if he'd collect my mail. "No problem," he said. "I'll keep an eye on things." 3 days into the trip, Mike texted me, "Saw surveyors near your driveway this morning. Thought you should know." I immediately called him. They were on my property. They stayed close to the road. I asked what they were doing, and one guy said they were working for the HOA. I frowned. The HOA never contacted me. That's what I thought was strange. I dialed Linda Mercer that evening. She answered on the 4th ring. "Mr. Carter." "Linda, why are surveyors on my property?" A brief silence followed. "They're conducting a neighborhood infrastructure assessment." "On my land?" "It's routine." "I wasn't notified." "You don't need to worry." That sentence irritated me more than anything else. "I'll decide whether I need to worry." She chuckled softly. "Enjoy your trip, Ethan. We'll handle everything." The call ended before I could ask another question. Something felt wrong enough that I contacted the county planning office the next morning. After checking their records, the clerk sounded confused. "We don't have any active county survey projects on your parcel." "None?" "No, sir." I thanked her and immediately emailed the HOA requesting every document related to my property. No response. 2 more emails. Nothing. Then, a week later, I received an envelope at my Denver hotel. No return address. Inside was a single sheet of paper. Across the top, in bold letters, it read, "Notice of Community Improvement Project." According to the letter, a necessary drainage enhancement would temporarily affect portions of my driveway to improve stormwater flow for the benefit of the subdivision. There was no engineering report, no map, no county approval, no permit number. Only a line at the bottom claiming the HOA board had voted unanimously to authorize the project. I called Linda immediately. "This notice isn't legal," I said. "It provides all the information required. It doesn't even identify who approved the work." "The board did." "The board doesn't own my driveway. It affects the community. It sits entirely on my deeded property." Her voice became noticeably colder. Mr. Carter, sometimes individual homeowners have to make sacrifices for the greater good. My property isn't a sacrifice. We disagree. I do not consent to any construction. There was a long pause. Then she answered with a sentence that sent a chill through me. Fortunately, consent isn't always necessary. The line went dead. I booked the first available flight home. Halfway through my layover, my phone exploded with notifications. Mike had sent 6 missed calls, then one final text. Ethan, they're tearing up your driveway right now. I tried to stop them. They told me they had full legal authority. You need to get home immediately. By the time I reached my house, the damage had already been done. Half my driveway was gone. The excavator had carved a jagged trench nearly 40 feet long, exposing crushed stone and clay beneath the concrete my father and I had poured decades earlier. Broken slabs were stacked in dumpsters like worthless debris. My mailbox leaned at an angle, and deep ruts from heavy equipment scarred the front lawn. But the county inspector's question about the permit had stopped the work almost instantly. Linda Mercer stood frozen while the inspector waited. Well, he asked again. I don't have the paperwork with me, she replied. Then where is it? Our management company has the file. The inspector nodded slowly. I'll need to see it before any additional work continues. The crew shut down the excavator. Engines went silent. Workers quietly gathered their tools, avoiding eye contact with both me and the inspectors. Within an hour, yellow tape surrounded the excavation site. The county had issued an immediate stop work order. That evening, I called the one person I trusted with property disputes, Rebecca Lawson. We had met years earlier when my engineering firm testified in a land boundary case. She was one of the sharpest real estate attorneys in Middle Tennessee, known for her calm demeanor and relentless attention to detail. When she pulled into my driveway the next morning, she didn't speak right away. She walked the entire length of the excavation with a notebook in one hand and her phone in the other, taking dozens of photographs. Finally, she looked at me. Ethan. What? This wasn't random. What do you mean? She pointed toward the trench. Nobody tears out a driveway like this unless they already know exactly where they're digging. That sentence changed everything. Rebecca immediately hired an independent surveyor named Daniel Pierce, a gray-haired professional with nearly 30 years of experience working for county courts. Daniel arrived 2 days later carrying old plats, GPS equipment, and a thick folder from the county archives. For nearly 4 hours, he measured property corners, located iron pins buried beneath the grass, and compared modern satellite coordinates with subdivision maps dating back more than 30 years. When he finished, he looked genuinely puzzled. Something doesn't add up. Rebecca crossed her arms. What did you find? Daniel spread several maps across the hood of my truck. The HOA claimed this excavation was inside a community drainage easement. It isn't? I asked. He shook his head. There is no drainage easement here. He tapped the oldest survey. In fact, this driveway has always been entirely within your recorded property boundaries. Rebecca frowned. So why would they claim otherwise? Daniel pointed farther down the page. Because someone submitted a revised site exhibit to the county about 8 months ago. A revised exhibit? It shows an easement that doesn't exist on the original subdivision plat. My stomach tightened. Who submitted it? Daniel turned another page. There isn't a county approval stamp. Rebecca immediately noticed the same thing. No filing number, she whispered. No recording information. No acceptance signature. She looked directly at me. This document was never officially recorded. Silence settled over the three of us. Then Daniel reached into his folder and pulled out one final document. I almost overlooked this, he said. It was an email obtained through a public records request. The sender was Oak Ridge Estates Property Management. The recipient was the county planning office. The subject line read, "Request to process easement revision after construction completion." Rebecca read it twice before looking up. They were asking the county to approve the easement. She paused, her expression hardening. After they finished tearing up your driveway. For a few seconds, nobody spoke. I stared at the email while my mind tried to catch up with what I was reading. They hadn't made a mistake. They hadn't misunderstood a boundary line. They had destroyed my driveway first and planned to ask the county to legalize it afterward. Rebecca slowly lowered the document. "This is bad," she said. "Bad for who?" I asked. "For them." She pointed to the email again. "Look at the date." I did. The request to process the easement revision had been sent 3 days before the excavation began. They knew they didn't have approval, I said. Rebecca nodded. And they moved forward anyway. Daniel added quietly, "In 30 years of surveying, I've seen sloppy paperwork, missing signatures and accidental encroachments. I've never seen a homeowners association start construction before the easement even existed." Rebecca's eyes narrowed. "Can you certify that the revised exhibit conflicts with the recorded plat?" "Absolutely." "And can you testify that no legal drainage easement exists on Mr. Carter's property?" "Yes." That was the moment the case shifted from a property dispute to something much more serious. Rebecca filed an emergency complaint in county court that afternoon, requesting damages, injunctive relief, and sanctions for unauthorized excavation. By evening, Linda Mercer knew we had the email. I found out because she showed up at my front door. Not alone. 2 HOA board members stood behind her, both looking uncomfortable. Linda held a leather folder against her chest. "We need to discuss this privately," she said. Rebecca happened to be inside reviewing documents. "Then you can discuss it with counsel present," I replied. Linda's expression tightened when Rebecca stepped into view. "I was hoping we could resolve this as neighbors." Rebecca smiled politely. "That's difficult after unauthorized excavation." Linda ignored her. "Ethan, the board is willing to reconstruct your driveway immediately." "With what permit?" I asked. Her jaw flexed. "The county issue is being addressed." Rebecca crossed her arms. "The county issue exists because your client performed work without approval." "I'm not your client," Linda snapped. "Then perhaps you should stop acting like one." The board members exchanged nervous glances. Linda took a breath and lowered her voice. "If this goes to court, things could become very unpleasant." I stared at her. "Is that a threat?" "No," she said smoothly. "It's a reality. Litigation is expensive. The association has substantial resources." Rebecca stepped forward. "So does discovery." That landed harder than any accusation. Linda's eyes flickered for the first time. Rebecca continued, "If we proceed, we'll subpoena every board email, text message, meeting record, contractor invoice, and communication related to this project." The color drained slightly from one board member's face. Linda recovered quickly. "You're making this adversarial." "You brought an excavator onto private property," Rebecca replied. "That made it adversarial." After a long silence, Linda closed the folder. "Then we'll see you in court." As they turned to leave, one of the board members hesitated near my porch. His name was Carl Henderson, a retired accountant who rarely spoke during HOA meetings. He looked back toward Linda to make sure she was out of earshot. Then he quietly said, "You should ask why the drainage project suddenly became urgent after the developer's inspection report." Before I could question him further, he hurried to catch up with the others. Rebecca looked at me. "What developer?" I shook my head. "I have no idea." She immediately opened her notebook. "Then that's where we start." The next morning, she filed subpoenas for the developer's records. 3 hours later, my bank called to report an anonymous complaint questioning the lien status of my property. By afternoon, fake notices appeared on the neighborhood bulletin board claiming I was blocking critical flood prevention work. And that evening, someone drove past my house and shouted, "Hope you enjoy paying legal fees." They were getting desperate, which meant we were getting close. 2 days later, Rebecca called me just after dawn. Her voice was unusually sharp. "Ethan," she said, "I have the developer's inspection report." "What does it say?" A pause. "It says your driveway wasn't the problem." My grip tightened on the phone. "Then what was?" "The HOA's new retention pond is failing." The courtroom was already half full when Rebecca and I walked in. Word had spread through Oak Ridge Estates faster than I expected. Several homeowners sat quietly in the gallery, including Mike Dawson and Angela Brooks. A few local reporters occupied the back row with notepads and cameras waiting outside the courthouse. On the opposite side, Linda Mercer sat beside the HOA's attorney, Richard Collins, dressed in a navy suit that looked considerably more expensive than his confidence. For the first time since this nightmare began, she wouldn't look at me. The bailiff called the room to order, and everyone rose as Judge Eleanor Whitmore entered. Once everyone was seated, Rebecca stood. "Your Honor, this case is about far more than a damaged driveway." It concerns an association that knowingly entered private property, destroyed permanent improvements without legal authority, and attempted to obtain government approval only after the work had already begun. Collins immediately objected. Counsel is arguing before evidence has been presented. Judge Whitmore looked over her glasses. I'll allow opening remarks. Continue. Rebecca thanked the court and sat down. Collins rose next. The association acted in good faith to address a serious drainage concern affecting dozens of homeowners. Any procedural errors were minor administrative oversights, not intentional misconduct. I watched several jurors exchange skeptical looks. Good faith? There had been nothing accidental about an excavator tearing through my driveway while I was hundreds of miles away. Rebecca called the county planning inspector as her first witness. After being sworn in, he testified calmly. Did the association possess a county excavation permit on the date construction began? No. Did anyone from the HOA present a valid permit after you requested one? No. What action did your office take? We issued an immediate stop work order. Collins stood for cross-examination. Is it possible the permit was pending? The inspector answered without hesitation. A pending application does not authorize excavation. No further questions. Next came Daniel Pierce. Large survey maps were displayed on monitors throughout the courtroom. Daniel carefully explained every boundary marker, every recorded plat, and every property line. Using a laser pointer, he highlighted my driveway. This entire structure sits within Mr. Carter's deeded property. Rebecca asked, does any recorded county document establish a drainage easement beneath this driveway? No. What about the revised exhibit submitted by the HOA? It was never approved or recorded. Collins attempted to challenge the conclusion. Could the revised exhibit have simply been awaiting processing? Daniel shook his head. It could have been awaiting approval. Until approved, it had no legal effect. Then Rebecca introduced the email. The courtroom fell silent as it appeared on the screen. Request to process easement revision after construction completion. She let the words linger before speaking. Mr. Pierce, what does this email indicate? It indicates the association intended to complete construction before obtaining legal authorization. For the first time, Linda shifted uneasily in her chair, but Rebecca wasn't finished. She called Carl Henderson. The retired accountant looked visibly nervous as he took the witness stand. After taking the oath, he glanced briefly toward Linda before answering Rebecca's first question. Mr. Henderson, were you present during HOA board meetings discussing Mr. Carter's property? Yes. Were all board members informed that no county permit had been issued? Carl swallowed hard. Yes. A murmur spread through the courtroom. Collins immediately objected, but Judge Whitmore overruled him. Rebecca continued. Did anyone suggest delaying construction until legal approval was obtained? Carl closed his eyes for a moment. I did. And what happened? He looked directly at the judge. Mrs. Mercer said. He hesitated. Take your time, Judge Whitmore said. Carl drew a deep breath. She said, once the concrete is gone, the county will have no choice but to approve the easement. They'll never make us put it back. The entire courtroom went completely silent. Judge Whitmore slowly turned her eyes toward Linda Mercer. Mrs. Mercer, her voice was calm. Would you care to explain that testimony before this court reaches its decision? The silence in the courtroom was suffocating. Every eye turned toward Linda Mercer. She looked at her attorney, then at the judge, then briefly toward the gallery where several homeowners sat with expressions that ranged from disbelief to outright anger. Her attorney stood. Your Honor, my client denies making that statement. Judge Whitmore didn't respond immediately. Instead, she looked at Carl Henderson. Mr. Henderson, you understand you're under oath? Yes, Your Honor. And you understand the consequences of perjury? I do. Is your testimony truthful? Carl didn't hesitate this time. Every word. Rebecca rose once more. Your Honor, the plaintiff has one final exhibit. The courtroom monitor lit up again. It wasn't another email. It was a video, my security camera. I had forgotten that one of the cameras mounted above my garage had continued recording until the contractor disconnected the power. The footage had automatically uploaded to cloud storage before going offline. The timestamp showed the morning construction began. Linda Mercer stood beside the excavator speaking with the site supervisor. The audio wasn't perfect, but it was clear enough. The contractor asked, "Shouldn't we wait until the county signs off?" Linda looked around before answering. "If we wait, this project dies. Once the driveway is removed, they'll approve it. Nobody's going to order us to rebuild concrete." The courtroom became so quiet I could hear someone in the back row gasp. Linda's attorney slowly lowered his pen. He didn't object. He couldn't. Judge Whitmore watched the clip twice. When it ended, she folded her hands. The evidence establishes a deliberate course of conduct. She looked directly at Linda. Not negligence, not confusion, not administrative oversight. This court finds that the defendant knowingly authorized excavation on private property without legal authority and attempted to obtain governmental approval only after the fact. She paused before reading her decision. The court enters judgment in favor of Mr. Ethan Carter. Relief washed over me so suddenly that I had to grip the edge of the table. Judge Whitmore continued. The association shall immediately restore the plaintiff's property to its original condition using licensed contractors approved by the county. The plaintiff is awarded full compensatory damages for property destruction, temporary loss of use, landscaping restoration, engineering costs, attorney's fees, and punitive damages based upon willful misconduct. She turned another page. This matter is also referred to the county district attorney for review of potential civil fraud involving altered property records and false representation submitted to a government agency. Linda's face turned completely pale. The judge wasn't finished. Furthermore, this court orders a forensic audit of the association's board actions related to construction projects undertaken during Mrs. Mercer's presidency. A wave of whispers swept through the gallery. Several homeowners looked stunned. Others looked furious. Outside the courthouse, reporters crowded the sidewalk. Microphones were pushed toward Rebecca. "Do you have a statement?" She smiled. This case was never about a driveway. It was about the principle that no homeowners association is above the law. Within days, the story spread across local news stations and regional newspapers. More homeowners came forward. One family discovered the HOA had entered their backyard without permission to install drainage pipes. Another found forged signatures on landscaping approvals. A retired couple revealed they had paid thousands of dollars in fines that were never authorized by the governing documents. The forensic audit uncovered years of misconduct, improper contracts, unauthorized spending, selective enforcement, missing financial records. Within 3 months, Linda Mercer resigned before the board voted to remove her. The HOA's management company terminated its contract with Oak Ridge Estates, citing serious governance concerns. Several board members quietly stepped down. Carl Henderson was elected interim president. His first motion passed unanimously. He eliminated the policy that had allowed the board to approve construction affecting private property without direct homeowner consent. As for me, 6 months later I stood on a brand new driveway. The concrete was stronger than the original, but what mattered most wasn't what had been rebuilt. It was knowing that the people who believed they could bulldoze someone else's rights had finally run into something far stronger than concrete. They had run into the law. Nearly a year has passed since that day. And every time I pull into my driveway, I pause for just a second. Most people see a smooth stretch of concrete leading to an ordinary house. I see something entirely different. I see the place where my father taught me that if something is worth building, it's worth protecting. I see the scars that once covered this property and the reminder that standing up for yourself is never as expensive as surrendering your rights. The neighborhood has changed too. Board meetings are now open, transparent, and well attended. Homeowners ask questions without fear, financial records are shared openly, and major projects require proper notice and legal approval. The sense of trust that had slowly disappeared is finally returning. Looking back, I realize this fight was never just about a driveway, it was about accountability. It's easy for people in positions of authority to believe no one will challenge them, but authority without responsibility eventually collapses under the weight of its own decisions. The law exists to protect everyone, not just those with titles, committees, or expensive lawyers. If there's one lesson I hope you take from my story, it's this: always know your rights, Keep good records and never assume someone is telling the truth simply because they sound confident. Sometimes, one document, one witness, or one simple question can change everything. Thank you for spending your time with me and following this journey from beginning to end. I truly appreciate every one of you. If you've ever dealt with an HOA, a property dispute, or a neighbor who crossed the line, I'd love to hear your story. What would you have done if you came home and found your driveway destroyed? Share your experience in the comments. I read as many as I can. If you enjoyed this story, please like, subscribe, and turn on notifications so you won't miss future stories about property rights, justice, and ordinary people standing up against abuse of power. Until next time, take care of your home, stand up for what's right, and remember, the strongest foundation you'll ever build is the courage to defend what is rightfully yours.